Hey, Curtis. Hey,
Let's move you over here, Rabia. Okay.
Now we're live, right? Yeah.
We're live. So this is where I go retweet things. Okay. Welcome to Let's Talk what? Let's Talk Immigration. Today is January 7th, 2026. And we have a lot to talk about. So Rabia, do you want to be the person that talks and tells me what to do?
Hi, I'm Rabia. I'm going to do the talking. Before we get started, I do see an error on X. It says it's not available. Just if someone wants to check on that. I just want to make sure that everyone can watch us.
It's available on my phone.
It is?
Yeah.
Yeah.
Okay, very good. Then hopefully it works.
Cool.
On my phone it says broadcast is not available. But yeah. Shall we dive? Go ahead, Curtis.
It's okay. We got 2 travel bans, 2 USCIS holds, and 1 DV hold pause. So 5 things to talk about. Which ones do you want to talk about first?
Should we start with the most immediate, the lawsuits that we have ongoing that are about to be filed that are all for the USCIS suspension?
Okay, that's great. So Friday, we are scheduled to file the first group lawsuit on behalf of 485 applicants that their adjudications are on hold because they're from countries related to the travel ban, whether that be the first travel ban or we've got 1 plaintiff in that case that signed up. That's the second travel ban. Believe it or not, I had the first draft of that complaint done except for the plaintiff's party section. So it's not ready to show to plaintiffs to review yet, but we are making a lot of progress on that. That lawsuit will be known as Saghafi versus Edlow, and it will be filed in the District of Maryland. Also, for you all that don't know, we actually have a couple of individual lawsuits challenging that hold memo that are pending. And in one of those, we have already filed a motion for preliminary injunction in the Northern District of California. And we've also filed a motion for expedited discovery, and we'll have a hearing in early February. So we know that judges will start looking at this as early as the beginning of February, even before we file our group lawsuit or before whatever's going on with Jim and Charles Cook's, Jim Atkins and Charles Cook's lawsuits. We know that in early February, judges are going to start looking at what's going on. So that's exciting.
Very good. It is exciting indeed.
And then the second thing is I-765. If you have a pending I-765 and it's on hold because of the travel ban, not because of the travel ban, because of the January 1st hold. Is that right? No, because of the December 2nd hold, then, or the January 1st, depending on what country you're from. Okay. If your 765 is on hold, you could participate in a group lawsuit we're onboarding now. We're basically onboarding 2 group lawsuits right now. The 485 group, although it's too late really to join and be concluded in the complaint on Friday, if you join now, you're going to be included in a complaint that's filed like in 30 days. Or the 765 case, which is filed next Friday. Basically, as soon as we get this one filed, I turn my attention to preparing the complaint for the 765.
Okay, I'll just summarize that. So the challenges we are filing, because I believe on our website it still says we are challenging the December 2 policy memo, but it's updated now. Very good. So people from all the 39 countries that are impacted by the USCIS policy can join if they have a pending I-485 or a pending I-765 or both, right?
Right, but it's separate lawsuits. The 765 challenge and the 485 challenge, two different lawsuits, right?
Correct.
But
And
both memos.
The 485, the I-485, the adjustment of status, the first challenge we are going to file on Friday, but we continue onboarding because, of course, the reality is that more people file adjustment of status and may need litigation. So our plan is to follow up with another lawsuit as soon as possible there.
Correct. And we already have plaintiffs for this because there were folks that did not want to be on the first lawsuit that decided to be on, not a lot. We just had one client do that today, right? That decided that they want to be on the second lawsuit, which is okay. That's fine. Okay.
Awesome. Then anything else on the USCIS? Do you want to give an update? Do we have any plans to start onboarding other benefit challenges as of yet, or are we looking at the DV challenge after the I-765?
Life at Ready Go Law is going to get complicated because we're going to probably start doing concurrent onboarding for another challenge of the USCIS hold and onboarding for the DV group lawsuit. We can do it.
Yeah.
I've got a plan.
Can I, and I hope that's okay, Curtis, really quick, take a second and on behalf of immigrants, thank you for ending your run for Congress and take all the time that you have to put us in the position that we can challenge as much as we can, because I believe that has a lot of value for the immigrants that are impacted.
Thank you. One of the key reasons I made that decision is that over I knew the last 7 days, the first 7 days of this year, I wanted to spend working on this complaint, and I did not want to spend preparing for a candidate forum and politicking. So it was sort of an easy decision. So
awesome. Yeah. Great decision. I'm personally happy that we get your brilliant mind back full time, and I'm sure many immigrants will be. You can just
you can't call me brilliant anymore in lives. That's prohibited, forbidden.
Okay, I'm sorry.
On that. So,
okay,
no, it's okay.
I would do that again. Let's move on to the travel bans.
Okay, before we get to that, I think Chuck is right here below us, and I just want to say that a lot of the people that are experiencing a USCIS hold issue are students, are people that have OPT, OPT STEM, H-1B, trying to go to adjustment of status from H-1B and stuff. And we are lucky to have Chuck as our resident expert of those areas. And if you wanted to have a 30-minute consult about the underlying USCIS issues related to those benefits, book that with Chuck on our website. I'm better talking about our litigation opportunities. That's really where my expertise lies.
Thank you.
Okay, so you said let's move on to the travel bans. Oh my gosh.
Travel bans, yeah.
Yeah, so there's two of them now, right? There's one from June 4th that had exceptions for like dual nationals and immediate relatives and Iranian minorities, and now
and Afghan SIVs.
And Afghan SIVs, thank you. But the December 16th one tore away some of those exceptions. Immediate relatives are no longer an exception. Afghan SIVs are no longer an exception, right?
Correct.
somehow Iranian minorities and dual nationals are still exceptions. And I'm worried about dual nationals. USCIS put some language in a footnote on the their January 1st memo that seemed to be critical of citizenship by investment. And I think maybe they might come after that dual national exception eventually. But right now it exists. So we've been getting a lot of questions on how people handle 212F refusals, right?
Yeah, I believe there is a lot of confusion and very little clarity whether one should attend an interview in this situation, if there's a realistic chance to be referred to a waiver during the interview, or if you basically put an end to your application by attending.
Right. And different attorneys will take a different view on this. So don't be surprised if I say one thing, another good attorney says something else. But my view, based upon just my approach to things, is always look out for what could go wrong. My view is do not attend an interview if you're not eligible for a visa. So if you are subject to the proclamation and you're not an Iranian minority and you're not a dual national, don't attend the interview. Because if you do, you could potentially exhaust that application, and that could put you at a disadvantage when the ban is gone 3 + 5 years from now. 3 + 5. Why did I say 3 + 5? I don't know. 3+ years from now, like after Trump is gone. So to avoid the risk of being at a disadvantage, I recommend don't even attend the interview. There's no, some people think that, oh, well, there's a chance they'll give me the visa because of humanitarian reasons or because of national interest. No, there's not. It's unfortunate, but there's no exception for humanitarian, and no one is getting national interest. So it's just not happening.
Okay. Yeah.
It's sad.
It's devastating, but yeah. Is there, since we did have a similar, not as broad, but similar travel ban under the last Trump administration, is there any precedent on what happens to children that may be aging out, derivative children on, let's say, family preference cases, right? Or other SIV cases where you have derivatives that may be turning 21 that typically are protected if they file a DS-260 and lock their age in by doing that.
Right.
Then
Okay.
more than a year may pass, right? Do we know what impact that may have?
I don't think we do. Maybe another attorney has a more solid view on that, but I don't think we do. I think it's unknown how applications will be treated after the ban is gone that were impacted by the ban. Let me tell you one of the reasons why that is. Section 212F of the Immigration and Nationality Act, also known as 1182F, it does not give the State Department the authority to refuse visas. It only gives the president the authority to refuse entry to a class of aliens. So since it doesn't give the State Department the legal authority to refuse under that, when they do it, they're freestyling. I'm trying to think of a word that would translate better. They're ad hoc. They're just kind of like, I don't know. Think of an analogy for that. They don't
like
have a rule.
Freestyling, actually.
What?
I like freestyling.
They're freestyling. Yeah. They've kind of gone outside the rules. And since they've gone outside the rules, it's hard to predict what's going to happen with respect to former 212F refusals. Because if they followed the law, there should never be a visa refused under 212F, because 212F doesn't give the State Department the authority to refuse visas. So that's why there's not a lot of regulation or law that that talks about what happens post proclamation rescinding or enjoining to 212F refusals, because they don't supposed to exist. Okay.
Yeah.
Pretty crazy. So any other questions you've been hearing out there before we go to the ones that are lined up?
No, we can go to those unless you want to talk about DV in specific for a minute before we go to questions which jump in topics.
Yeah, so I'm excited about how much interest we have in our DV group lawsuit. We have an interest list set up on our website. It's a little bit tricky to find, but that's because we've got a lot going on right now at Red Eagle Law. I'm going to show you how to find it. If you are a DV 2026 selectee, go to our website and then click on the three little bars over here, lawsuit interest list, DV 2026 interest list. By the way, our other interest lists are below there. But the DV 2026 interest list, you can register here. This isn't registering for the lawsuit. This is just letting us know that this is just telling us who you are so we can let you know when we start onboarding, which I hope will be within a few weeks, maybe a month, something like that. Okay. I was going to tell you how many people, but I have to find it. Give me just a second.
Okay.
It just got shared with me. How many people are on this interest list? 439 people have signed up on the DV 2026 interest list. So that's a lot of interest. So this is a lawsuit that we do want to go ahead and start work on. Yeah.
Very good.
Okay.
Love to hear that. Alrighty, then let's jump into questions. The first question we have is from Adam. What about those who passed the interviews but had their visas canceled? I would just assume that that's asked in the context of a travel ban country nationality. So if a visa was canceled.
Right. So this is a very fact-specific question. I need to know when your visa was canceled and how that happened. So I understand, like back in June 9th, that there were some folks who CAC issued, they got their, but then when they got their passport, the visa was stamped and it said the visa stamp said revoked or canceled. Those folks are now out of luck because they were relying upon I'm trying to figure out a way to talk about this that's not confusing. The effective date for that proclamation is no longer relevant because we have the effective date of the new proclamation. So if this has happened to a new wave of people, it would not surprise me. You need to come to me with your individual situation for us to talk about it. I need to know dates. When was the cancellation happened? When was the past the interviews? I don't know what
passing the interviews oftentimes referred to when you complete the interview.
Right. It doesn't mean that the visa was issued. So it might not have been canceled. So I just need to know more about that specific situation. So reach out to us, do a consult. Or just message me on Telegram and I'll answer at night.
Oh, on X. The question is from X. Twitter X.
Well, you can DM me. I get behind on DMs, actually. But I'll try to do better. Okay.
Okay. Then thank you so much. We'll go to the next question. Is there any chance to have immediate relatives back as exception from the proclamations?
Well, I mean, it's entirely possible. I mean, but you would need to change Donald Trump's mind. And to change Donald Trump's mind, you need to probably change Stephen Miller's mind. And that's probably not possible because I don't think he has one. So I don't know. I think the odds are 99% chance that's not going to happen.
Thank you. Not what we want to hear, but honest. James, season's greetings. Happy New Year, James.
He's my most loyal subscriber. James is. Hi, James. Okay.
What are your thoughts on group lawsuit versus individual lawsuit for pending I-485 to change the policy?
Okay, first, you need to understand that if you are filing a lawsuit this is different from an unreasonable delay mandamus lawsuit, where you file the lawsuit and the hope is that the government's going to moot it out in a short period of time, and you're not going all the way to the merits of the lawsuit. That's not true when you're challenging a policy. So when you're challenging a policy, if you want an outcome within 3 to 4 months, you also need to file more aggressive motion practice. You need a motion for preliminary injunction. In my view, a motion for expedited discovery. That's what we've done in the case in the Northern District of California. And so that's more money. Okay, so you're talking about spending over $20,000 if you want to do that with us. If you want an individual lawsuit with a motion for preliminary injunction challenging the ban. So obviously the group lawsuit, first benefit of a group lawsuit is it's more affordable because group lawsuit's only $3,000, and it's also not all at once. It's $1,000 up front, then we charge $2,000 later. Okay. Now there are actually many pros and cons. The biggest pro I like with a group lawsuit is on a motion for preliminary injunction, you have to prove that there's imminent irreparable injury, and we get to benefit from the aggregate harm from a group of people all having harm. Rabbi has worked very hard over the last couple of weeks on declarations for our 485 case, and I can't imagine what's in her head right now with all the harm that's being caused this group. I mean, I think we have, if I'm not mistaken, we have doctors that won't be doctoring, right? Like, you go to the hospital and your doctor won't be there because guess what? The USCIS ban has prevented him from getting a screen card, or her. So, crazy harm. Okay. And so we get to benefit from the aggregate harm of everybody stacked together, but also the most compelling harm. I had a case in 2020 where our lead plaintiff was a 9-year-old girl from Syria who was there by herself. Like, that was very compelling, especially when Syria was being bombed at the same time. So I would say that there are advantages to group lawsuits, and advantages to individual. And another, although I'm skipping around, an advantage to an individual is that it can be very customized to your specific situation. Sometimes people come to us with wanting an individual lawsuit, and they have multiple pending applications that are delayed or on hold, and you can put them all on there. Where with a group lawsuit, we want everybody to be the same situation. We want everybody to have stuff in common. And that you don't have to worry about that when you do an individual lawsuit. With a group lawsuit, we have more venue options. We can file in more places because if we're challenging a policy, it's venue for one, venue for all. So if we find one plaintiff that lives in a district, well, we can file the lawsuit there, and everybody else is properly joined because we're challenging the same unlawful policy. So we have more venue options, which court to file in with a group lawsuit than we do with an individual. So,
okay. Do you see any chance, that's the second question here, that the hold gets lifted as a whole?
It's possible. I don't think it's realistic. And the reason I don't think it's realistic is the Trump administration doesn't normally do things. They don't volunteer to do the right thing. If the Trump administration does the right thing, it's because they're being compelled to by a judge. So I think what is probably more likely is we will see 4, 5, 6 different judges weigh in and on our favor, probably one that doesn't, because that's just the way life is. And then after this stream of judges weigh in and say that these USCIS holds are unlawful, what'll happen is either the nonprofits will step up, or maybe we'll step up, or Charles or Jim, and file a motion for class certification. Just get a class certified and get relief for everybody. Because it'll be obvious that it's like, you know what, this would just be easier if we do it this way.
Thank you. The next question is about DV. Embassies are permitted to schedule interviews, but everyone is being refused under 221G. For the lawsuits, will there be follow-up opportunities for those who interview later in the fiscal year?
Well, first of all, we aren't onboarding that lawsuit right now, the DV. The lawsuit challenging the hold and pause of DV applications, we're not onboarding that yet. In the past, I would say in the year 2020 and 2021, as analogies, we filed waves of lawsuits. Like in 2020, we filed Muhammad, Fangjong, and then Kennedy. In 2021, we filed Jacob, and then we filed Good Luck, and then we filed another one. Is it Tessafe? No, that was 2022. We filed UAO, and then we filed Tessafe. And I think one Hamid or something. So typically there are one or two later lawsuits, especially if we have success. If we don't have success on the first one or two lawsuits, it's less likely that we will continue moving forward with more lawsuits. But
Do we already know if interview and 221G refusal is going to be a requirement to participate, or is the hold enough that that applicants that have not yet had their interview can participate in the challenge as well?
It's a difficult situation because different judges look at standing in different ways, but I'm inclined to include people in different positions with a lawsuit that's filed earlier in the fiscal year. So if we're filing a lawsuit in late February, early March, I'm okay including people in every situation as long as they're DV 2026 selectees. But the people that probably have the most to lose would be the folks that have gone the furthest. If you've already had your interview, if your case is current in the visa bulletin, then and you don't face another barrier. If you're from Iran and you face the other barrier related to the travel ban, I'm not sure if you want to get invested in removing one barrier if you can't remove the other. So keep that in mind. Say Iran, but also like any of the 40 travel ban, 39 travel ban countries plus the Palestinian Authority. So it's 40, I guess.
Yeah. So DV applicants from rest of world everywhere face the DV suspension challenge, and the people from the 39/40 countries also face the travel ban. So the DV challenge would be the first barrier, and then they get stuck at the second. Okay.
Yeah, I don't know which one's first and second, but they're both barriers. Yeah.
Yeah. Yeah. Maybe. Yeah, they could potentially also get entered as codes at the same time.
Yeah.
Joe is asking, the oath ceremony was canceled because they're from Venezuela. Green card is from 2019. What should I do? I live in New York.
Okay. Sign up on our interest list, and we will let you know when we move forward with a group lawsuit for N400s. There's two places on the interest list for that. There's N400 pre-interview, N400 post-interview. And the reason we did that is because those two groups are differently situated. If you are post-interview, we could also do a 1447 action. So I had to separate those out. So when you're doing the interest list, in this situation, scroll down to N400. Oh, no, it's at the very top. There's N400. Oh, it doesn't show on the screen. See, there's N400 pre-interview, and then I'm changing it, N400 post-interview. So make sure you choose, in your situation, post-interview, because you already had, it's at your oath ceremony, so you already had your interview. So you're in a good situation. I wish you'd told me when your interview was. Here's why. Section 1447B says that a federal judge can determine whether or not you are a U.S. citizen. They can take that power away from USCIS. It's the only situation really where we get to sue and the judge gets to be the decision maker of the actual application. So, but he can't do that for 120 days after your interview. So, in your case, your post-interview, sign up on the interest list. I hope you're from Houston, because I have a group of 4 already in Houston. I'm ready to add more and get that filed.
Very good. Abshir is asking, hi, there are a lot of conflicting takes on the travel ban. Some firms are saying we suggest to postpone consular interview. You do not want to collect the 212F refusal. That's the end of your visa application. I don't think that's in your interest. Then some others are saying go, because there's no way around the 212F, no waiver exists. What should we do? And do you think the ban will get lifted anytime soon for immediate relatives? We talked about that before. I think he probably just joined a little bit later.
Yeah, but I like it the way he's framed it. Which view do you take? And I take the view, don't go near a U.S. embassy if you're not eligible for what they're offering. If you can't buy what they're selling, don't give them money, because they will take it and they'll say thank you, and you will not get a visa. So I don't see. I know that some other smart attorneys are saying go ahead and go to the interview, but I don't see the purpose of that.
Also, Curtis, I want to add that the last travel ban we had, how they resolve that is that after Biden administration, they just take off the old Trump travel ban and then reopened all the cases. So we don't know.
Not all, I think, right? Some had to reapply.
Right, not the DVs.
Very
and some had to
distinct.
reapply.
Yeah.
But the thing is, Biden allowed for that to happen. He did that as an accommodation in his proclamation. He actually ordered the Secretary of State to find ways to try to make things right. We do not know with certainty that will happen in, 2030? When's the next election? I should know this.
2028.
2028. We don't know if, when the next president takes office in 2029, if they rescind the ban, if they're also going to do an accommodation. So that's why I do not take the second view. I take the don't go to the interview view.
And then it's very important to be in contact with the State Department every 12 months. I think that's important to know, because that way you can actually delay the application and prevent it from being marked as inactive for multiple years, right?
Or exhausted, yeah. 203G is a very interesting section of the law, because I think it's probably unlawful, but it's impossible to get a court to consider it, because in the few times I filed a lawsuit where they tried to cancel an application under 203G, the State Department just gave up, and they were like, okay, fine. We're going to bring the application back to life. Because of that, federal judges never get to look at 203G to say whether or not it's lawful or not. So, I don't know. It's a funny provision of law.
And what it does is it basically says, as long as there's activity.
In its essence, it says that if you abandon an application for more than a year, then we can cancel it. But it doesn't make sense in the context of the fact that the agency doesn't even email you back within a year. I mean, like they tell you on their website, don't contact us. They tell on one part of the websites, especially the Middle East, Encore and Yerevan, they have on the website, don't email us for like 6 months. And then they'll go cancel an application under 203G because they're like, you didn't email us.
But let's translate that into into an actionable thing for the applicants. So
Okay.
that means in the reverse, as long as they are in contact with the embassy every 12 months, the application cannot be canceled by the State Department?
Right, but don't trust them. Save your evidence. So when you send visa, what's it called? Visa Navigator inquiry, or you send them an email, I recommend doing both. Save evidence of that. Save it as a PDF in a little folder in your on your laptop. Probably the same place you file your tax, your little folder for your taxes, because you have to do it once a year. Do it on the first of the year or something like that, or a birthday. This is for your mom's application. Do it on her birthday every year. Just get a day that's a ticker every day, because this is going to go on for 3 years. I'm sorry, at least.
All righty. On to the next question. Bemuniri is asking if one files a lawsuit against the hold for I-485, and they also have an I-765 application. Can the judge also rule that the hold for the I-765 should be lifted, or should they sue for that separately?
Great question. My view is that they should sue for that separately, but it's possible that it happens.
Why would an I-765 approval be needed or adjudication be needed if the judge orders the I-485 to be adjudicated? I think that's my counter question.
Right. And here's where we have to go back to, like, we're talking about what's going to happen after a judge's order without saying what's in the order. Judges are not like, I keep wanting to bring up that meme of that guy that goes up and goes like this or goes like that, like back in the Roman times. What movie is that? You know what movie it is?
The Gladiator.
Gladiator. He goes out there and he's like, yeah. Judges don't do that. Okay. Judges have to write opinions that are dozens of pages, sometimes 100 pages long, that address the arguments that were made by the plaintiffs and the defendants and why the judges made a reasoned decision on what their order is. And so they're very specific about why they did what they are ordering and what they are ordering. It's not like this or this. And so in this case, it's possible that a judge's opinion says it is unlawful for you to use national origin as an excuse to withhold benefits from plaintiffs. If we get a judge to say those magic words, that would apply not only to the 485, but to all other applications, and also to the November 27th memo, because that's using national origin. So what the judge's words are in their opinion and order matter. And we actually have a precedent for that. Anybody goes to the Morrison Urena website, DV 2020, on September 4th, 2020, Judge Mehta issued an order, injunctive relief for our plaintiffs and for the plaintiffs of some other lawsuits too that were consolidated. And then the government thought that they would apply another presidential proclamation to prevent our plaintiffs from getting issued visas. It was like called the COVID proclamations. But long story short, we went back to the judge, and the judge said, no, you don't. The judge said, you needed to follow my guidance that I put in the first opinion, that it's not lawful for you to do it this way. And so he gave what's called a supplemental order, supplemental relief, and stopped them from doing the additional mischaracterization of the law. So I think that that's what could play out here, and that's what I'm hoping plays out.
Thank you. Then the next question, and I will combine the text of the next two because it's from the same person and each of them has important info for you to respond. So this is an Iranian UK dual national with a B1, B2 visa in a P for an EB2 NIW. Wants to know if travel on the B1, B2 can be made to the US while being in administrative processing for the immigrant visa.
Yes. You agree, Chuck?
Yeah. Also, when you are in the U.S., if you can stay very long, after 90 days, you can submit 495 to adjust status.
Except it cannot be the plan.
Yeah.
I agree with Chuck
Yeah.
that is an option that many people follow, but they do not plan it that way.
Yeah,
because
that's why the 90 days rule.
You cannot enter the U.S. with the intent to permanently reside in the U.S. on a non-immigrant visa. But you can make that decision after you're here. You can't make it today. Was there another part to this question?
Yeah, no, that was the question. There's just lots of info across the two. Just if travel on an NIA and a non-immigrant visa is possible while the immigrant visa is in AP.
Cool.
Okay.
Let's back up. Let's go a little deeper here to make sure people understand this. There's a reason why you might not be interested in doing what I just speculated that is done a lot, and that is because you have Iranian citizenship also. They would not give you a decision on your adjustment of status, and you would get stuck in the United States indefinitely. And a lot of people may not want to do that right now. Okay.
Yeah. Okay. Then Atsufan is saying, thanks. This is the same question again. We can skip over that. If Democrats win the midterms, is it possible to overturn the situation and force the admin to lift the ban?
No, Democrats would need to win more than the midterms. And if you're wondering, what would that mean? I don't know. Democrats, we're locked into a president for 4 years in the United States. So yeah. Democrats winning the midterms just means that Congress could change what the law is. But when you've got a White House that's sort of ignoring what the law is, they would have minimal impact. I mean, it's important. We have to do it. If we don't win the midterms, they're going to have to close hospitals and airports and stuff. We're going to change civil society the way it works. So we definitely Democrats have to win the midterms, but it's not going to be the silver bullet. It's not going to solve all our problems.
Thank you. The next question. My parents are Afghan nationals and their case is currently at the interview stage. Should they proceed with the interview or wait until the ban is lifted?
Well, Rabia, you do a lot more work with Afghans than I do, and would you agree with me that they should not attend the interview? Or do you
I totally agree. I would not attend, especially similar to Iranians. Afghans need to travel to even attend an interview, right? So you have visa situations to get to a third country. You have to travel. You need accommodation in the third country. That's a lot of money for knowing that it ends your visa application.
Yeah.
So I wouldn't do it. Just keep in mind what Curtis said earlier. It's important to keep in touch with the embassy once per year so the case doesn't get inactive.
Okay.
But, yeah. Then the next question is the same again, the UK B1, B2 traveler. And then we have Chipyong with a thumbs up, thumbs down. I don't know what you like and what you dislike.
No, he's making fun of me talking about that movie. Later.
Okay. Bemoniri says, thanks a lot. And then here, the UK visa, I don't enter US with an intent to stay in the US or adjust status. It's purely a temporary visit. Yeah, that's a great plan.
Great plan. Hey, I want to switch to something somebody in our back room just pointed out. Did you know that there was US visa news on the website yesterday? I did not know this.
The visa bonds?
Yeah. You would know this. So U.S. visa news, there's an update on January 6th. The Department of State has identified nationals from these countries. I wish they would say citizens and not nationals. these two words mean something else. From these countries as needing visa bonds. The implementation dates are in parentheses. Why wouldn't they make them all the same day? That's a lot of countries. How many countries is this? I don't know. Visa bond requirements. So this is for non-immigrant visas. Is it just for B1, B2? $5,000, $10,000, or $15,000?
And they can only enter the US through 3 airports. Does it looks like that? Or scroll further down? Yeah.
Oh my gosh, it's the worst 3 airports on earth.
Leave JFK alone. I really like JFK for processing.
Okay, that's good. I don't like Logan because it was raining one time for like 3 days, and I spent 3 days in the airport because somehow they put an airport in Boston where they're like, we shouldn't fly planes when it's raining, and I'm like, you're in Boston. Okay.
Yeah.
Anyway.
I from what I heard also Boston and Dallas, DC, you can just get stuck waiting in lines forever. JFK is a little bit the East Coast version of SFO. They have so much experience in processing people. It's just a quick in and out, typically.
That's true. Okay. So visa bonds, this is a new thing. I don't have a lot to say about it because it's the first time I'm reading it. So they're making it more difficult to enter the United States. Kind of like North Korea. That's what we're doing here. So I see another question popped up here.
There was a travel ban lawsuit in the last time Trump was in office in 2020, or I don't remember exactly. Oh, multiple travel bans under Trump 1.
Yeah, there was multiple ones. The signature one that was filed in the Northern District of California was PAR's Equality Center. It was consolidated with a case called Amami, and that lawsuit went on for all of Trump's administration and most of Biden's. And just last year, they won summary judgment and actually got a little bit of relief for people that were victims of Trump's travel ban. Not wonderful relief, but like waived fees and priority appointments. But those benefits are already over. But I personally filed at least a dozen group lawsuits challenging Proclamation 9645, the first Muslim ban's waiver provision. And then there were, Chuck worked with me on, well, Rabbi, you were around back then. We were challenging Proclamation 1.
Okay, I was a plaintiff.
Yeah.
2020. I was not working at the firm. I was a plaintiff.
But that's okay. That's part of the same. It's work to be a plaintiff. So yeah, Proclamation 10014. People don't know this. During Trump's first administration, during COVID, everybody's news is focused on the COVID and people dying and him telling us to drink bleach and stupid things. And at the same time that was going on, he enacted the most comprehensive immigration ban in the history of time. Proclamation 10014 stopped almost everybody from coming to the U.S. And so there was a lot of litigation.
And they want to do it again in Project 2025.
Project 2025. Are they going to do a virus too, or just the bans without the virus?
I think the Freedom Caucus just diverted to suggesting to suspend all immigration until new immigration laws have passed. That's the latest proposal. I dropped it actually in our.
Yeah, I saw. I just didn't click on it.
Yeah, I saw the alien land law is also in it.
Yeah, Saba, you may not have seen that, but the question that you have on the screen right now was actually expanded to the specific question about Trump v. Hawaii.
Okay.
If the ruling in Hawaii would have any impact on challenges brought today, I think.
Okay, so the very first chance window you will have to kind of learn about that is if you want to listen in to the hearing in Thine versus Trump's appeal, which will be that's our lawsuit challenging the travel ban in DC, challenging the June 9th, June 4th travel ban, because that order, we weren't happy with it. The government wasn't happy with it. They appealed. We cross appealed. And so there's actually oral arguments. Is it February 19th?
On Thursday, February 19th.
Yeah. Yeah. So those are in DC. Chuck, you're going to go to DC too?
Yeah.
Okay, cool. Our associate Garrett Carter May is going to make oral arguments. Chuck is going to be his second chair. I might come. I don't know yet. But Trump versus Hawaii is what the government's argument is. They're like, Trump versus Hawaii, Trump versus Hawaii. And we make the argument that non-delegation was not addressed in the same way in Trump versus Hawaii as it should be addressed here. Things are very different about the proclamations here from Trump's first travel ban. I'll give you an example. Togo, one of the reasons Togo hit the travel ban was because of the overstay rate of B1, B2 visitor visas. Well, why would you, it's not rationally related. Why would you suspend entry of immigrant visa applicants because non-immigrant visa applicants overstay their visas? Does not make any sense at all.
And at the same moment, the government would argue if an immigrant who did immigrate to the United States goes back home and stays for too long, lost their green card, right? So that's
confusing. I have to think about it. So what are we getting at here? Oh, so we argue things are different now than Trump versus Hawaii. The government argues they're the same. So we'll see what happens.
Thank you. James is asking if there's any DV 2027 update. There's no update.
No, except I was thinking about it in the shower this morning. How am I going to file that lawsuit? How am I going to monetize it? Is everybody going to give me $1 every 2027 not selectee because they can't get selected? Anybody thinking about the DV20? Anybody that messages me DV 2027 update, instead give me $1. I'll have enough money to file it. Or what we could do is make that cause of action, like piggyback it, like make it an extra cause of action in the DV 2026 lawsuit, because every DV 2026 selectee would be a potential entrant for DV 2027.
Yeah.
Just decided that's how I'm doing it because I can't think of any other way to do it.
Okay.
So the way we're going to challenge DV 2027, see, this call was very useful, James. Thanks. The way we're going to challenge DV 2027 suspension is we're going to challenge it in our DV 2026 hold, pause lawsuit. I never know whether or not to use the word hold or pause because USCIS is using the word hold, and the State Department's using the word pause.
Okay.
So,
shall we move it along? We do have a few more pending, no, actually a bunch of pending questions and 6 minutes left. Focus on, I'm from Haiti. In June, I transferred my case to the Bahamas, but unfortunately, Haiti was on the list of the ban. In October, I postponed. Do I have to keep postponing until 2029?
I would not bother. You could if you don't have anything to do, but the reality is you did not attend interview, and that's not going to change whether or not they put you on the calendar or not. They can't refuse you if you didn't attend interview. Right?
Awesome. So you would suggest he postpones?
I would suggest don't even worry about it. But I mean, if you want to be courteous and just email them and say, I'm not going to be there, that's a courteous thing to do.
I think no, he did already postpone, wants to know if
he should
postponing needs to continue. And I believe so if you actually rescheduled your interview in, let's say, US visa scheduling or whichever system Bahamas is using, you don't want to do that. You want to contact the embassy and postpone your interview and let them know you will reach out when you are ready to be rescheduled, because the third-party providers like US visa scheduling and so on and so forth, they stop allowing you to reschedule at some point. So you don't want to bother with that. You want to email the embassy, let them know you're not attending this interview, and you will reach out when you're ready to be rescheduled, that you're still very much interested in pursuing your immigrant visa.
Yeah.
That you'll follow up. How long after the group lawsuit do you expect to get a positive answer on the applications from USCIS? I want to join the group lawsuit. I have an I-485 pending, and I'm from Venezuela.
3 to 4 months is the goal. That only happens because we're doing a motion for preliminary injunction. That's the only way you can get things to happen that fast. 3 to 4 months is the goal.
Okay. For N400, not yet interviewed, is there a chance that the hold will be lifted for dual citizens, Iranian, Canadian?
There's not, okay, I don't need the other context. There's a chance that it will be lifted, but I don't think so. I think their plan, if you pay attention to Stephen Miller and Project 2025, their plan is to shut it all down. They don't want people coming to the U.S. They want the people that are here. Wasn't it New Year's Eve? They shared a little meme where they said 100 million people deported. That's their goal. So don't expect the people who have a goal of deporting a third of America, don't expect them to do something friendly.
Thank you. Zaba's following up. I know things can turn out in any direction, but how likely are we going to get preliminary injunction? And why USCIS? Okay, yeah. First, the preliminary injunction on I-765.
Oh, my confidence rate is definitely 85%, maybe higher on the 765, because the plaintiffs have extremely compelling situations, including cancer doctors. I've got a 765, at least one, probably more. There's a lot of doctors with this situation, right?
Yeah.
That's very compelling for a judge. Judges in the U.S. tend to be older. I didn't know if you all knew that. To see that, oh, we might not have cancer doctors because they don't have work authorization. So I'm very confident. So let me see the last part of the question. Why USCIS is processing the application normally and just holding the decision? Well, it's because that's what the memo said. The memo said that that's their new policy, so that's why. Okay. And this is our last question here. Oh, it's not a question.
It's not a question, but you have a good evening too.
What's peace out mean when it's purple and blue? Maybe I shouldn't ask. Okay.
Do you see chances of success with an N400 lawsuit?
Yes. Extremely so. Both pre-interview and post-interview. Okay. So thank you, everybody.
Thanks all.
Thanks, Chuck. Thanks, Rabia. I'm going to click on end. Okay. See y'all next week.